We're very pleased to have a very distinguished panel on the 13th Amendment. As moderator, I have two choices. The most desirable one from my perspective is to talk about who the panelists are and their achievements. The only problem is that would take the entire session. The alternative is simply to start and say Professor Fano has agreed to speak first, and everyone will take their 7 minutes. Thank you.
Okay. That was a short and sweet introduction. I want to thank everybody who was responsible for this conference because it's very fascinating indeed. Although I, as a historian with no foothold in a law school or anything like that, although some of my best friends are law professors, I wonder whether what my role is really, because this came out in some of the questions in the last session. I am not particularly interested in the original intent of the 13th Amendment, at least insofar as Supreme Court justices try to talk about that. In fact, from the point of view of a historian, I have no interest at all in what Supreme Court justices think about that. As a citizen, it's very important to me. They are fairly incompetent in analyzing history, as many of their decisions of the past generation, Ted Shaw was talking about this, have illustrated. Most of the members of the Supreme Court have no real conception of American history as it pertains to race, the Civil War, racism, and things like that. So, but of course, what they do think, even when misguided, has a great impact on our society. Nonetheless, as a historian, of course, I am interested in the Reconstruction era and in what the people who wrote the 13th Amendment had in mind, because that's a historical question. But when historians analyze that question, we don't just look, as some legal scholars, not all by any means, but some do, we don't just look at the debates in Congress. We try to look at the entire spectrum of opinion in the society at that time. The original, one might say the framers of the 13th Amendment included many people who were not in Congress and indeed had no voice in politics in 1865. There were no black people in the 39th Congress. There were no black people in the legislatures that ratified the 13th Amendment. Nonetheless, if we see the 13th Amendment as the culmination of the emancipation of the slaves, African Americans had a great deal to do with that process, as we know, and we ought to try to think about what their conception of emancipation and freedom was. Or to put another way, it's an interesting question how we get that African American voice into debates about the original meaning of the 13th Amendment. Their vision of abolition was not expressed in congressional debates. It was expressed in political meetings, in churches, on plantations, in actions like running away from slavery, etc. And they were concerned, if we look at debates in the black press in 1864 and 65, in political meetings, they were concerned with issues like equality before the law, the right to vote, economic independence. They feared that a constitutional amendment abolishing slavery would not actually settle those questions. One black abolitionist, James McCune Smith, warned, quote, "The word slavery will be wiped from the statute book, but the ancient relation can just as well be maintained by cunningly devised laws." In other words, they were concerned not just with the abolition as a constitutional and legal matter, but in with substantive freedom. One newspaper at the time described the Civil War Congress, the 38th Congress, which ratified which passed the 13th Amendment, as, quote, "the Congress of the Revolution." It's important, and as a historian, to remember, A, that the 13th Amendment was quite a radical measure in the context of Martha Jones actually mentioned this briefly last night, in the context of emancipation in the 19th century, and indeed in the context of American history. The 13th Amendment was immediate, it was nationwide, it offered no compensation to slave owners, that is to say, it simply abrogated the right of property in slaves with no compensation. It made no distinction between loyal and disloyal slave owners. It made no provision for apprenticeship for freed people, as they had tried to implement in the British West Indies. And it said nothing about colonizing the former slaves outside the United States, which was a very popular idea, including held for a long time by President Lincoln. The ideas of gradual compensated emancipation linked to apprenticeship and colonization had widely circulated before and during the Civil War. Even the Emancipation Proclamation, which was immediate and offered no compensation, did not apply, as we all know, to all the slaves, and Lincoln continued to think about colonization even after that, after the Emancipation Proclamation. In fact, the New York Herald in 1864 said that the 13th Amendment was a rebuke to President Lincoln, a rebuke that, quote, his petty tinkering devices of emancipation will not answer to the situation confronting the nation. Of course, Lincoln did eventually work hard to get the 13th Amendment passed by Congress. I do want to, despite this question of original, that I'm not interested in original intent, I do think it's important to remember that most Republicans in the Congress that passed this amendment adhered to what I once called the free labor ideology. The most common phrase in the congressional debates was the right to the fruits of one's labor. That's what the emancipation of the slaves was supposed to accomplish, to get blacks the right to the fruits of their labor. How do you do that? And one might almost say that the 13th Amendment might be revived as a measure which would be able, through which one would be able to attack the gross economic inequalities which have afflicted African Americans. They have never enjoyed the right to the fruits of their labor in the same way that white people have since the ratification of the 13th Amendment. If anything was the purpose of the 13th Amendment, it was, as Senator Harlan said, the enjoyment of the proceeds of their own labor. Since I see I'm just about out of time, let me just say one other thing. At the very beginning of the Civil War, a Northern pamphleteer shrewdly commented that the question, quote, what shall be done with the Negroes, was a question about white people, not about black people. It was a question about what kind of society would emerge after the destruction of slavery. It meant, he said, quote, how will their freedom affect us? And therefore, I think, even though race, quote unquote, as we heard, was a key motivation of the 13th, 14th, and 15th Amendments, they were really efforts to define a new kind of American society, an American society in the aftermath of slavery, but one in which the rights of all people, all Americans, all citizens, were redefined, and in which the meaning of freedom was changed for everybody. How that gets implemented, I think, is still a question that confronts us as a society today, and as long as that debate continues, we can expect or perhaps hope that new meaning will continue to be infused into the 13th Amendment. Thank you.
Lisa?
So like Eric, I'm interested in the openness of the meanings of the 13th Amendment and also in looking at where the meaning of the 13th Amendment comes from outside of professional legal circles. But I think I'm more interested than Eric in the relationship between what goes on outside of professional legal culture and what goes on inside of it. And I look at, I think about complaints made by African Americans and others as being the place where the lawmaking process starts, right? When somebody has a harm that they understand to be a legal harm that they take to a lawyer, and the lawyer then transforms that into language that can be cognizable in court, the lawmaking process starts with the complaint, and then it works its way into what courts eventually do with those harms. And unsurprisingly, legal professionals take their cues not only from the complaints themselves and from the popular understandings of the 13th Amendment and other parts of the Constitution, but also from particular political and legal currents and jurisprudential currents of any given time. And I'm going to talk about three eras. I'm going to focus on one, but I'm going to talk briefly about the Lochner era and then focus on the New Deal era and then end with the Civil Rights era, the more recent Civil Rights era. So the first and the third are kind of bookends to the main thing that I want to talk about in showing the ways in which the meaning of the 13th Amendment in the law has taken on different life in different periods of time. So in the Lochner era, a time when liberty of contract was particularly salient, whether you are a traditionalist or a revisionist, it remains salient. The successful cases under the 13th Amendment were involuntary servitude cases that involved contracts, peonage cases about debt, where someone was forced to work for someone else because they were indebted to them. And the analysis of those cases focused on contract and debt. And the 13th Amendment was almost understood as not allowing specific performance for work contracts. If you read Bailey v. Alabama in particular, you get that sense that the court is understanding the 13th Amendment in connection with its 14th Amendment due process jurisprudence. Now, this is not to say that the only kinds of involuntary servitude in the early 20th century were involuntary servitude incidents that involved contracts. There were tons of other manifestations of involuntary servitude, but these were the ones that became legally cognizable, and these were the ways in which courts talked about them. In the New Deal era, things change, and the main period I want to talk about in my 4 minutes remaining is the New Deal era, and by that I mean basically from the mid to late 1930s until Brown in 1954. And there, the meaning of the 13th Amendment as lawyers began to understand it really drew upon the New Deal legislations, New Deal ideas about governmental protection. So during the Lochner era, one of the ways that people understood the role of the government was as an occasional umpire overseeing private arrangements. So when those private arrangements go wrong, occasionally the government has to intervene. In the New Deal, the government takes on a much more robust role. And the idea is that the government is a protector, an affirmative, positive protector of the rights of the people. And you can see this in lots of New Deal legislation and in understandings of rights at the time as being really about security in lots of manifestations. So there are three main ways in which the New Deal comes to inform what the 13th Amendment means, particularly for a group of lawyers in the Civil Rights section of the Department of Justice that gets created in 1939 to protect civil rights, whatever that means. It was in flux at the time. And so one of them is a change in this notion of the role of the government. And African Americans make claims that they deserve protection too. The main ideas about security at the time were largely economic security. This is obviously the Depression. And there comes to be this idea that African Americans have rights to what's called the safety and security of the person. And these include 13th Amendment rights to be free from bondage. They include rights against police brutality, rights to vote. So there's a sense, this I think goes back in some ways to the dignity conversation we were just having, right? There's a sense of autonomy and bodily integrity and security that the government is supposed to protect. There are also two substantive ways. So I would say that that's a role about, that's informing lawyers' conceptions of the 13th Amendment in terms of what the role of the government is. And I would say that that also affects what complaints they think are cognizable and what complaints they think they can push forward. So suddenly it's not only complaints about contracts that make sense to these lawyers, but complaints that involuntary servitude is enforced through violence or through threats of violence or through threats of imprisonment. And before there hadn't been an available vocabulary, an available constitutional vocabulary for lawyers to use and to convince courts. And starting in this New Deal era, they draw on the 13th Amendment in a much more direct way. The second and third ways in which the lawyers understand the New Deal are both about the substance of the 13th Amendment. New Deal legislation largely excluded African Americans in the South by excluding domestic laborers and agricultural laborers from their protections. And these lawyers in the Civil Rights section understood the 13th Amendment as kind of filling in the gaps of that legislation. They said, if you don't have the right to labor mobility, the right to organize, the right to bargain collectively, the kinds of rights that the NLRA granted to many white workers, you actually don't have labor freedom. And they invoke the free labor ideology, but it means something different in the New Deal era. It means the labor protections of the New Deal. And then finally, they invoke economic security also from the New Deal, and they talk about how you can't actually be free unless you live and work under certain minimal conditions of, again, dignity, I think. And this comes out of the Fair Labor Standards Act and Social Security and various other kinds of economic security legislation. And African Americans, as I say, were left out largely from these protections, especially in the South, and the 13th Amendment comes to be understood as providing these protections as a bulwark against involuntary servitude. So in that sense, the complaints that become cognizable in this new paradigm include those against labor immobility generally, not just in a specific labor of relationship. So immigrant agent licensing laws and vagrancy laws and hitchhiking laws all come under attack there. And then finally, when it comes to economic security, suddenly complaints about the way people live and the conditions under which they work, even if they are not actually held, physically held, or out of tremendous fear, held in a particular employment relationship. So there's a woman who works as a domestic worker, and she says, I live in a chicken coop, and I'm fed terrible food, and I work from dawn until dusk, and I'm not paid, and I'm only allowed to leave the house to do errands. In another era, leaving the house to do errands means you are not a slave, right? You can leave, you should leave. But the way the lawyers understand this in the New Deal era is if you are so enslaved physically and psychologically that even though you are allowed to leave the house, you remain in the custody of your employers, then you obviously don't have the kind of freedom that we contemplate under the 13th Amendment. Okay, so I'm out of time, so I'll just say that by the 1960s, the late 1960s, the 13th Amendment comes to mean something very different. It comes to be used basically as a 14th Amendment without a state action requirement in the post-Brown era. And building on this is my last sentence, I promise, Mark. Building on the question of where we go from here, I think, in thinking about what pasts are usable, that it makes sense not to look only to the usable past from the Reconstruction era, but to the elaboration and the process of elaboration the last panel was talking about, and the meanings that the 13th Amendment has had in the past.
Thank you. I very much appreciate the opportunity to speak at this conference, and I think the organizers of the ACS have done just a fabulous job of coordinating these things. My argument is going to be that the 13th Amendment provides a powerful alternative for civil rights legislation at a time that the court has scaled back Section 5, 14th Amendment, congressional powers, and Commerce Clause powers. In the immediate aftermath of Reconstruction, the court diminished congressional powers, both in the civil rights cases and in Plessy v. Ferguson, to pass legislation under the 13th Amendment. But there was a revivification of those powers in the Warren Court, in Jones v. Alfred H. Mayer, that found that Congress could pass any laws under Section 2 of the 13th Amendment that were necessary and proper to end any incidents of involuntary servitude. The Berger Court took up that strand and found that the 13th Amendment enabled Congress to prohibit inequalities or discriminations by a private school in Runyon and by a private pool association in Tillman versus Wheaton Haven. Now, I want to turn to the comparison of Congressional Commerce Clause and 13th Amendment powers. The Commerce Clause and the 13th Amendment are similar insofar as they both allow Congress to prohibit private acts of discrimination. That was first found to be the case in the civil rights cases and confirmed in Jones and in Runyon. The defining cases on Commerce Clause, of course, are Heart of Atlanta and Katzenbach versus McClung, that both used a rational basis of review. Well, the court has recently significantly scaled that back, and rather than using rational basis of review, in Lopez, it said that Congress cannot pass any laws pursuant to its Commerce Clause powers unless the activity had a substantial effect on interstate economy. In Morrison, case that struck the Violence Against Women's Act, civil provision, found that violence against women did not have a substantial effect on the interstate economy, despite the fact that 8 congressional hearings and 21 state task forces had found that, in fact, that was the case. So with this recent trend of Commerce Clause jurisprudence indicates that the 13th Amendment might be important in the future for ending private acts of discrimination. First of all, the Commerce Clause is always going to be subject to economic counter-arguments. But the 13th Amendment is only incidentally concerned with the economy at all. It's about liberal equality and about principles and rights. And the communicative value of the 13th Amendment speaks to these rights, while the Commerce Clause is completely neutral. In fact, it existed side by side with slavery. Besides that, the 13th Amendment is applicable to intrastate cases, while the Commerce Clause is only applicable to interstate cases. So let me give you some examples. My argument is that we should take a very incremental approach to avoid the possibility that the court will find a way of striking Jones. So along this line, Violence Against Women Act could be reenacted, the civil provision could be reenacted. How? I recommend that it be reenacted pursuant to the 13th Amendment to have to do with the workplace, so that we connect it with the incidence of involuntary servitude and labor and not go beyond that. And then through this incremental approach, perhaps take the next step after that. Senator Edward Kennedy had the Matthew Shepard Act, which I helped to formulate, and that did not go through in the last Congress. We're hoping that it might in the current one. And that law was a very broad reading of hate crime statute that applied to groups of sexual orientation. I think that it at least has a possibility of being struck if it ever makes it up to the court and if it gets out of Congress from a bill into a law. So I think, first of all, we need a severability provision, that is to say enacted both under Commerce Clause and the 13th Amendment if it's found unconstitutional under one, at least it survives, and also link it to more labor-oriented things, violence in the workplace. And I'll speak back to that again in just a minute. Now I want to go back to the 14th Amendment and speak about this comparison with the 13th. First of all, 14th Amendment, we are told, has a state action requirement. Not so with the 13th Amendment, making it a powerful alternative. So a whole set of cases that cannot be handled under the 14th Amendment can be under the 13th Amendment. So besides that, there's been a further diminishing of this power through this responsive reading of the 14th Amendment. The court has recently found that Congress can only pass acts if they are congruent and proportional to some sort of a remedy or to prevent an injury that was caused by a state misconduct. The 13th Amendment, on the other hand, hasn't been touched as far as Congress's ability to pass substantive laws by determining what a fundamental right is and by passing a law to end any incidents of involuntary servitude that are reasonably connected to some history and fundamental rights in the United States. So here are two approaches. The first is a narrow approach, the one I recommend following because I think it's much more likely to survive judicial review, and then let me talk about a broader approach. On the narrow approach, again coming back to this gender violence, we have two methods of acting on gender violence if it comes in the workplace. One is Section 1981, but that requires a contract violation, or the TVPA, the Trafficking and Violence Protection Act, but that requires coercion. I coerce you to stay at work for gender or for other reasons. Well, but if I tell you you can leave, but I beat you up for gender reasons, I don't have a cause of action against you. If I don't violate any employment contract, there's no cause of action. So the way to deal with it, I think, is to pass a law in the workplace. This violence against, could be a gender right issue, pursuant to the 13th Amendment, doesn't include coercion, doesn't include contract violation. Now, we're years away, I believe, from any true idealistic approach to the 13th Amendment, but let me just take a stab at it. Another relevant place where the 13th Amendment might be applicable is with associational rights, right? Part and parcel of slavery was blacks or slaves' inability to associate in churches, at playing dice, at dancing, in all sort of manner of conduct. So clearly that was an incident of slavery, and when people became free, they embraced that ability to go see family members elsewhere and to join in church groups and so on. So associational rights, I think, are clearly linked to the incidence of involuntary servitude. So Congress, again, I'm talking about Section 5, Congress could pass a law that would prohibit discrimination by associations. Again, it would work better if labor rights were involved. In other words, if a person were working for an association, one could, then you could say, well, you can't do that. And if you do, then that individual has a cause of action. Well, wait a minute, the Boy Scouts, that's kind of labor, right? And that's an association. So maybe those are some associational rights that could be handled. Furthermore, the associational rights are closely linked to residential issues. Now, the Fair Housing Act, as it currently stands, requires that in filing a cause of action, there has to be some federal spending that's given to a residential place. But that's not true of the 13th Amendment. So there could be a provision prohibiting discrimination in housing, including sexual orientation discrimination, even in circumstances where there is no federal spending. I've got other ideas, but no time to talk about them. Laws against racial profiling, laws against hate speech on the order of Virginia v. Black, the cross-burning case, and prohibiting U.S. companies who use slave labor overseas. So in summary, the 13th Amendment gave Congress a powerful means of determining what a rational way of ending any incidents of involuntary servitude are. And while the 13th Amendment has very broad potential to increase federal involvement in the area of civil rights, success is more likely to come through an incremental approach.
Thank you very much. I'm glad to be here. I have to say, when I was asked to join this panel, I was a little confused at first. I'm not a historian or a law professor who does history. And then I thought maybe, well, I'm a clinician, a clinical law professor, and if there's a disenfranchised, subordinated group at the legal academy, it might be clinical law professors. But I don't think that was it either. I can say I have actually litigated 13th Amendment cases. I used to have a 13th Amendment docket, and maybe one day more lawyers will be able to say that, and maybe one day soon. The 13th Amendment is a relatively blank slate, I think. It is a relatively under-litigated provision, and for that reason has a certain appeal. The hope is that constitutional litigation is not yet constrained by adverse judicial precedent in the way so many other facially promising constitutional amendments are. If I had to ask myself today in the United States, what group of people most suffer involuntary servitude, forced labor, peonage, the manifestations of slavery that were also on the minds of the Congress that enacted the 13th Amendment, I would certainly have to say that immigrants in this country are probably the population most subjected to those sorts of practices, and therefore potentially the population that could most benefit from creative legal strategies to apply the 13th Amendment in the 21st century. Now, I think that the easy part here is the individual instances of horrific mistreatment in the workplace. As Risa said, the domestic worker who's confined in the home. These circumstances do happen today, and I think undoubtedly violate the 13th Amendment's prohibition on involuntary servitude, as well as the statutes that have implemented it, even under current case law. There's no need for further case development to hold that. This is the most recent statement by the Supreme Court on the topic, that actual or threatened physical or legal coercion to work constitutes involuntary servitude under the 13th Amendment. That's United States against Kosminski. Well, that is certainly what happens when an immigrant is threatened with deportation and is threatened, that is the threatened coercion, that the state will back up the private relationship. What I want to talk about is something a little bit broader, not only the specific instances of 13th Amendment violations today, but what I think are two structural features of our current labor and immigration laws that I think the first violate the letter, and the second seem to violate the spirit of the 13th Amendment, and certainly the more robust conceptions of the 13th Amendment that others have elaborated. These two features are first, the temporary worker programs we have now, the employment-based visas, under our current statutes admit about 1 million people a year to come in on temporary visas and work. For many of these programs, one's immigration status is contingent on continued employment for the specific employer approved by the immigration services. In other words, if you quit, you are immediately liable for arrest and deportation. Now, reading the peonage cases, I take from them not only that there's a concern about coercive private contracting, but coercive private contracting backed up by state power is certainly at the core of part of what the 13th Amendment was after. And in the peonage cases, state law after state law were invalidated because one who quit could end up going to jail. Now, those were criminal sanctions. Today, the jail that immigrant workers worry about, of course, is immigration jail. And I don't think it's a stretch at all to say that if the right to quit, which is what these cases so powerfully articulate, means anything, it has to mean that you can't go to jail for quitting. But we admit about 1 million people a year who end up roughly in this situation. I'm generalizing. There's an alphabet soup of visa categories, and there are some details in some of them that matter here. But in general, we live under a regime in which the right to quit does not exist for hundreds of thousands of workers, and if they did quit, they could end up in jail. That seems to me inconsistent with even a narrow vision of the 13th Amendment, inconsistent with its history and its case law. And it matters. It matters, of course, not only for the individuals subject to that circumstance today, and for all of those who live and work and worship and raise families with those individuals, but also because in this moment we are debating massive immigration reform proposals, almost all of which contemplate very substantial expansions of the temporary worker programs, and by and large do not commit to the notion that temporary workers have a right to quit. Some proposals do, some proposals don't, but there's certainly a very real possibility that the current situation will grow much larger in coming years because we will approve new laws that will allow additional temporary workers into the country without the ability to change employers and thereby to protect themselves from workplace predations. The second structural feature that I think raises serious 13th Amendment implications today is the statutory prohibition on the employment of unauthorized immigrants. Let me stop on that one for a moment. I was just talking about legal immigrants who forfeit their immigration status and then become liable for arrest if they quit their work with their approved employer. I'm now shifting to undocumented workers. There may be 12 million or more undocumented persons in the country, nearly all of them working. By law since 1986, we prohibit the employment of unauthorized workers, and the courts have held that that, as a statutory matter, therefore excludes undocumented workers from other labor and employment protections, in particular, right of reinstatement if discharged, and the right of back pay if discharged, which means an undocumented worker who tries to join a union, protests sexual harassment, complains about a dangerous condition, and is fired, which is unlawful, has no remedy available to them. And this creates, without question, the kinds of coercive labor conditions that, at minimum, the 13th Amendment in spirit and in its broader conceptions was intended to foreclose. It excludes from the basic labor and employment protections of this country millions of workers who are set aside into a different status. I'm already out of time, but I will just say one final thing, that the notion that the 13th Amendment might have contemporary and significant meaning for immigrant workers in this country is not only an extension of the logic of the amendment and its text and its case law, but is also not inconsistent with the history of the period. And I'm not a historian, I'm not an originalist, but I am a lawyer, and history does matter to judges, and sometimes it even wins the day. And so arguments that are at least historically grounded tend to be better received in the courts, of course. The history of the 13th Amendment is primarily focused, naturally, on the eradication of slavery. But, and this is particularly evident in the history of the 1870 Act, in which protections for the right to contract and inherit and purchase property were extended or confirmed to reach non-citizens. There's substantial history in those congressional debates about the situation of Chinese workers in California and the need to ensure that they too are protected by the statute that is now the basis for Section 1981 and Section 1982. In 1874, Congress passed the Padroni Act, pursuant to its 13th Amendment authority, protecting Italian boys who were being brought into this country and exploited from the special circumstance of immigrant workers. And even the early cases, such as the Slaughterhouse case and Robertson against Baldwin, generally cases that narrowly viewed the 13th Amendment, recognized that the words involuntary servitude in the 13th Amendment contemplated not only slavery, but also what the court called Mexican peonage and the Chinese coolie labor system. You see these echoes, these sort of background recognitions that people subject to the grossest kinds of labor exploitation included immigrants, even in the late 19th century. That is picked up, and I'll close with this, in the later cases, in the 20th century cases, the primary peonage case is Pollock against Williams from 1944, which includes a long description of one instance of contemporary peonage, which is foreign workers taken up to the forests of Maine and isolated and exploited there. And this is the example of contemporary peonage the Supreme Court looks to. And then in Kosminski, 1988, the final case in this line, the Supreme Court says a threat of deportation could constitute coercion for the purposes of involuntary servitude. So there's this secondary theme throughout the history of the 13th Amendment that recognizes the particular applicability to foreign laborers. And I think if we ask today who might most benefit from even the narrowest conception of the 13th Amendment, it has to include foreign workers. Thank you.
Thank you. I think I'm going to exercise the moderator's privilege and make a comment and ask sort of a question. The comment is to observe that the Plessy versus Ferguson dissent was not rooted in the Equal Protection Clause, but in the Guarantee of Republican Government Clause. Off of that, now, can you imagine Earl Warren without any of the post-Civil War amendments, using the Guarantee Clause and some other clauses, and generating a line of progressive precedents that do not depend at all on the 13th, 14th, and 15th Amendments, and one could see those being elaborated. And if you can, which exercise are we doing these 2 days? One, are we trying to elaborate a constitutional vision that we think this new government ought to push? Or, given past precedents, are we simply trying to shoehorn our own particular policy preferences or constitutional preferences into existing doctrine and possibility?
Is that a question?
It's either it's a
Is
question.
that a rhetorical question?
It's a rhetorical
or
question.
real
It's sort of it's a question for all of us. But I thought I could take 90 seconds, and with that, the floor is open. Is that a hand, Barry?
And I think, like a lot of the academics here, I'm fascinated to hear about litigation possibilities and legislation possibilities, and I can't hear enough, quite frankly. But one of the things that struck me listening to the panel, and I think this is congruent with Mark's point, which is I'm curious on the one hand about litigation, launching litigation that we're trying to sort of fight our way around precedents with a court that may not be favorable or a set of facts that may not broadly appeal, versus on the other hand, if there is a legislative program that we think is advisable, this strikes me as exactly the right point to push it and to see what happens on the court. So it's true that there are these sort of difficult court precedents, but the court decisions came down involving legislation that had been passed by a Democratic Congress that at the time that the cases were heard had been replaced by a Republican Congress, and the court really had very little fear about pushback from Congress if it started striking down legislation. And I'd be far more interested to see what the court did with progressive legislation passed by a sitting Congress that seemed to have strong majorities about it. I suspect that some of the middle justices, one in particular, might be shoved around a little bit.
You know, it occurs to me as a historian that, and this perhaps is not the right place to say this, especially because this conference is sponsored by the Constitutional Society, that the real problem is the Constitution itself, or perhaps it's constitutionalism, which is so deeply ingrained in our culture that we don't even wonder whether it's a good idea or not. It took a British historian, W.R. Brock, in a great book on Reconstruction called An American Crisis, published in the early 1960s, to point out that the existence of a written constitution was a great barrier to creative thinking during the Reconstruction period. You did have a few far-sighted people like Thaddeus Stevens from Pennsylvania who said, look, let's get serious here. This has nothing to do with the Constitution. The South is a conquered territory. We can do anything we want with them and forget about the Constitution. That was the fact. But nobody else wanted to go that route because they all were within this constitutional mode of thinking and saying we must square our provisions with the Constitution or perhaps change the Constitution if we want to implement various kinds of policies. And therefore they did change the Constitution in very important ways, as we know. But, you know, all these Marx questions, the other question, it just, you know, there doesn't seem to be any way around it. But, you know, maybe it'd be better to live in a society like Britain, where Parliament can just pass good laws, and they don't have to worry about constitutional amendments passed 140 years ago or shoehorn them into that kind of mode where you're obviously perhaps doing it in a way which is how shall I put it, very pragmatic rather than constitutional. But I'm not advocating that we abrogate the Constitution. I'm just saying we ought to realize how constitutionalism itself is, as Brock said, a barrier to creative thinking.
There's also the point that Sumner, of course, thought that you pass amendments without allowing the South to vote on them until they were really reformed. And then we would have had much broader amendments in their applicability. But can the guarantee clause be used? And could it just be Republican form of government? Well, we certainly know that line of thinking with the radical constitutional abolitionists did not work. Right? In fact, that's what they were arguing. Guarantee clause, Republican government, guarantee of Republican government, and also Fifth Amendment were their big arguments. Preamble was a big argument. So, one argument that I've made, right or wrong, was that the radical Republicans were in charge in '66. They were in charge of the major committees, and it was their opportunity to put the principles of the Declaration and the preamble into a constitutional amendment. Now, I don't think they did that in a spectacular way because partly Trumbull and the Senate Judiciary Committee decided that they were going to choose part of the Northwest Ordinance as their language. Why part? Because they didn't include the Fugitive Slave Clause, which comes right after the clause that they chose. And so this very narrow reading, excluding equal protection, which Eric talks about in the paper that he's contributing, more could have been done. But I think without constitutional amendment, having the 3/5 clause, having the other clauses, and Bill Wysick has pointed out that many other clauses, including the Commerce Clause facilitated the interstate exchange of slaves. I think it required constitutional amendment so that people like the Garrisonians who thought, would have been brought on board in the possibilities of making the American creed a reality.
I mean, to Barry's question, I don't think it's necessarily an either or. I mean, I think as Ted Shaw said, we have to push from the outside in all fronts. And so we should explore how far this Congress is willing to go, and we should offer up justifications for what it's willing to do that will best ensure the survival of the statutes it passes. And in my view, we should challenge the judiciary to be involved in this conversation also. And of course, there's dialogue between those branches. So it's not so much an either or. Maybe it is in a given day. How do I spend my afternoon? Do I try to work on a statute or work on a brief? But I think there's opportunities to be pressed in all of those places. And it can't be coordinated particularly. So I kind of support the idea of a ferment of activity. But we should attend to all of those opportunities and not put all of our eggs in one basket, of course.
Risa wants to speak, then Richard and Christina have questions.
So I was going to respond in part to Eric. Well, I mean, I think you could modify what you said and say that the Constitution is actually a spur to creativity, right? And that the incredibly vital constitutionalism that we all seem to be a part of actually requires creativity in order to make arguments within the paradigms that courts seem willing to accept. And my project is mostly backward-looking and not forward-looking, but I do think that when you look backwards, you see the way the choices about what to do on any given day are made, right? And sometimes they're made as the path of least resistance, right? So in part, the reason that these New Deal lawyers in the Justice Department did 13th Amendment cases because they were afraid of Plessy. And sometimes they took Plessy on directly. And I was really struck when Ted Shaw said, we just have to find a totally new place, because when I look back at what lawyers do, it's pretty rare that they look for a totally new place. They're trying to find ways, and I think this goes to something that Riva said, right? They're trying to find ways to cobble together a new place out of suggestions that are already there. And I'm not saying I think Ted really thinks we need to find a totally new place. It doesn't base on that. But I was struck that what I see most in the past is creative thinking that draws on history, precedent, language in ways that seem to push the boundaries, but do so in the least provocative ways that they think judges will accept.
May I suggest, rather than sort of one comment and then 14 minutes of discussion here, that we take a range of comments and all of us finish up. So, Richard, Christina, Riva.
Richard Primus from the University of Michigan. I love delivering good news, so I want to deliver a piece of good news to my great teacher, Eric, and it goes like this. We do live under the British system. Oh, right. Or, I mean, it overstates the case, but only a little bit, right? Which is to say, we have, it would come as great news to British lawyers and British politicians that they labor free of constitutional constraints. And it's not necessarily the case that had there been no inherited document of 1787, that the Northern Republicans would have reconstructed the South in the way that Thaddeus Stevens wanted. There were all sorts of other obstacles to doing that, failure of will, failure of resource, so on and so forth. You can attribute the problem for the written Constitution, but words on paper don't get up and do things, right? And one of the things that happens in a society with a written Constitution over a long period of time is that the written Constitution becomes less and less important, and that what actually influences what happens in government comes to be all sorts of other things. Conventions of practice, habits of thought, political will. And that's pretty much the same here as in Britain, except that one feature of our constitutional culture is that we talk as if the written document made all the difference, right? If we really base but it's very much the habits of thought and so forth that control. If they weren't, we wouldn't need the 13th Amendment to have no state action doctrine. We could run everything through the 5th Amendment, right? And we could have a judicially self-executing feature to do everything that Alex wants on the basis of the due process clause there. There's no state action requirement, but no lawyer would ever do that. And the reason isn't that the text prohibits it, it's that that's not how the system works, and many people think that it's a good thing that the system doesn't work that way. So what you actually have to do is convince people to think differently about who we are and what's possible, or you have to change the grand narrative and the grand set of expectations. If you do that, the textual readings will follow, right? And if you have judges who think differently, and that may be a generational process, the decisions will follow, and then you can perfectly well do workmanlike things like say, well, try this clause and not that clause, but what you have to change is the grand narrative and the set of expectations.
Christina?
Hi, I'm Christina Rodriguez from NYU. My question returns us back to the meaning of the 13th Amendment. And the basic question is, when do you know that we've shifted from coercion to consent? And in the way that the understanding of the 13th Amendment has evolved, has there been an evolution in understanding of what kinds of terms someone can bind them to? And I think the guest worker example provides a really difficult case, because the conditions that are created, especially in the most egregious circumstances, are ones that very much resemble institutions that we thought the 13th Amendment was meant to do away with. But yet there's also a consent to enter into that form of contract. And I would suspect that the further we move away from the instance of slavery and the replication of that through the black codes, that the more likely courts or other actors, political actors, are willing to say that the conditions to which people bind themselves are broader in range and potentially more negative in scope, particularly when you're dealing with a contract that, though it has these implications that might lead to exploitation, are also contracts that are empowering ones for the people who are coming from societies where their opportunities are much less viable. And so how does the evolution of labor practices and our move away from the original paradigm case change where we define that point of transition from coercion to consent?
Reva?
Just a brief thought. First, on the guarantee clause, I've long thought it the case that almost every clause of the Constitution that the abolitionist movement claimed on as a matter of popular constitutionalism was treated as judicially unenforceable in subsequent, that there's a, you know, the preamble, the guarantee clause. There's also great uses of Bill of Attainder, Title of Nobility, which is, all of these have no development, and probably, given the lively claiming on the 13th Amendment outside of the courts, it's also affected the court's willingness to actually give it judicially enforceable meaning. But in any event, I thought the panel started to open up a really interesting exchange about the way in which this history matters. Mark, you were suggesting that we might be bringing values to the ways in which we're reading the past, and so in some sense that makes the project suspect. But Risa invoked the idea of usable histories and usable pasts at the beginning of her remarks, and maybe the point is that as a practice of constitutionalism, not as a practice of history, as a practice of constitutionalism, that some of this material is not going to control what we do, but allow us to talk about progressive aims across normative communities. I think Richard has used a concept of mobilizable histories in one of his pieces that I thought interesting. That is to say, pieces of our past that we could use to talk about values that matter within a progressive community to a somewhat larger range of people. And that's a very, very different picture about the role that, I mean, I think that's what Peggy's work, where is she? That's what Peggy's work is, oh, there she is, what her book is trying to do. And I think that there's real promise in looking at the history in that fashion, but it's a different view about what the role of the past and the narratives of the past might be. And that would be one in which we might find a lot of material in post-ratification history in the way that Risa is inviting us. Indeed, if you look at parents involved was invoked earlier as something for progressives to worry about, I continue to think there's more to be said about looking at Kennedy's position in there. But that aside, a deep thing about that case is that everybody was claiming on Brown. You know, the court that decided Heller this past term was divided the same way, but all of the 14th Amendment history that they were focused on was the history of Brown versus Board. That was the shared common history from which our normative dispute was emanating. And that's, if we look at the actual shape of our constitutional practice, we'd see that very often these kinds of, the history that matters, like, for example, the history of the New Deal in our Commerce Clause jurisprudence, is all post-ratification history. So the point is to note how it is that these stories matter and think about the ones that could be important situationally in elaborating norms that the society might be open to, but about which it has a different vision, divided vision of the good.
I think Neil had a question and someone, okay, Neil and someone over there. The gentleman over here, okay. Well done.
Hello. Yes, my name is Irvin Goodson, and I'm from Lehman College, City University of New York, and it's a great pleasure for me to be here. The question that I have, I'm going to ask my question last, but I want to preface it by certain marks and excerpts that I have. Some scholars have commented on the penal implications of the phraseology and construction of the 13th Amendment vis-a-vis the accept clause, accept as punishment for crime. And I'd like to just read an excerpt from Professor Fano's book, if he would allow me, Reconstruction, America's Unfinished Revolution. And I found this very interesting, and it talks about an enslaved person who was just, I guess, recently freed, and he says, "I ain't never heard nothing about jails and slavery time," a Georgia freeman later remarked. "What they done then was most beat the life out of us." Okay. And then it goes on to say, abolition obviously required a restructuring of enforcement machinery, as George A. Trenholm, a prominent merchant, explained soon after the end of the Civil War. Here, too, these depredations were either overlooked or the culprit punished lightly and restored to favor. Now, it must necessarily be different. Theft is no longer an offense against the master, but a crime against the state. Okay, now I would like to piggyback that on with Charles Sumner's arguments in the Reconstruction Amendment debate, which he rather strenuously argued against the phraseology and the use of the exception clause. And history tells us in Maryland and in the Reconstruction conventions that they had in the South, some Southerners explicitly saw the exception clause in the 13th Amendment as a loophole, which was a bridge to the black codes. And I would like to end my comment by saying, to reinforce this, to make it a little bit more contemporary, I'm not a lawyer, but I'm an historian, but I'll give you a case of Meacham versus Fano in 1976, and it says, at one time the prevailing view was that the deprivation was essentially total. The penitentiary inmate was considered the slave of the state, which was a case Ruffin versus the Commonwealth in 1871. Although the wording of the 13th Amendment provided some support for that point, the courts in recent years have moderated the harsh implications of the 13th Amendment. So my question is it possible that the construction / phraseology of the 13th Amendment has had an unintended consequence of adversely affecting African Americans vis-a-vis incarceration / imprisonment?
Okay, Neil, and then I think we'll ask the panel to respond.
This is an invitation to sort of recess-style creative thinking, right? And I'm thinking specifically about the relationships among the Civil War amendments, right? So I'm not thinking so much in terms of Alex's suggestion that we go to the 13th Amendment because the 14th Amendment has been ruled effectively out of bounds in many ways, but might our understanding of, say, the 14th Amendment be informed by the 13th Amendment? And I'm thinking about how striking Section 1 is, right? There's no state action requirement. You can't be a slave or a slave owner. You have to look, where else do you look to find that? Section 2 of the 21st Amendment, right? That there's no state action requirement. And does it make sense when the 13th Amendment is situated so close to the 14th Amendment in both, not just text, but in time, right, to enforce a state action requirement under Section 5 of the 14th Amendment, like in Morrison, the way the court has done? Now, I don't know that this is going to move Kennedy to reconsider the holding in Morrison, but I do think he's very concerned about dignitary harms. I do think he moved in parents involved. I do think he's more reachable, certainly, than anyone else who's likely to be decisive for the indefinite future. And so I think an interpretation of the 14th Amendment that takes into account, right, just how striking and distinctive Section 1 of the 13th Amendment is, right, I think would at least allow for the possibility, well within our constitutional traditions, of not enforcing state action to the extent that the court has.
I think what we'll do, we'll go in reverse order all the way down.
Okay, much has been said. I'm just going to pick out 2 points. I'm sure others will hit many others. First, a little more narrowly, but on Christina's point. Christina made the argument that employers made in the peonage cases in the first half of the 20th century and said, well, wait, you entered voluntarily into that debtor contract or that fraudulent contract. You knew, and therefore, how can it be involuntary servitude if you voluntarily entered into that arrangement? And so, too, don't guest workers voluntarily agree to the terms of their visa when they come over. That's what the employers said in those cases. And they had a sympathetic audience in the court in Robertson against Baldwin in 1897, and then they lost it. And so the Supreme Court said in Bailey against Alabama, which Risa mentioned, peonage is sometimes classified as voluntary or involuntary, but this implies simply a difference in the mode of origin, but none in the character of the servitude. And so the Supreme Court in Bailey against Alabama and thereafter said it might be voluntary and involuntary at the start, but involuntary servitude addresses everything after that, and thereby rejected the point that you made that the employers argued there and said even if you knew the terms at the beginning, if you are in a situation where to quit means going to jail, that is involuntary servitude, even if you knew that going in. More broadly, my response to that last point, maybe a litigator under Republican years, is a nervousness. The more we push the 13th and the 14th together, I worry about the 14th becoming a drag on the 13th, rather than the 13th somehow reinvigorating the 14th and maybe pushing us out of some of the constrictions there. That's a predictive point, nothing more than that. I think the move is an interesting one, but I frankly worry more about losing what's still free and clear rather than rethinking the 14th Amendment.
I'm also just going to begin with that last point. You know, the interesting thing about the debates on the 13th Amendment is nobody thought of the 14th Amendment. They thought that that was it. They had not amended the Constitution for a generation, and for decades, and they thought that this was going to be final. It wasn't until Johnson vetoed the Civil Rights Act of 1866, even though the debates on the 14th Amendment begin before that, that there's a major push. In fact, Sumner says that very close to the time that the Senate votes, says that we should include an equal protection clause in the 13th Amendment. And Trumbull and another member of the Judiciary Committee say that's completely unnecessary because it's just obvious that what we're talking about is equality here. The issue of citizenship, which very few people thought was not covered under the 13th Amendment, almost everybody did. It was a supermajority that voted the Civil Rights Act of 1866 into law with a citizenship provision clause, and very few didn't agree with that. That was something that they wanted to secure against a president like Johnson, who was going to be a drag on Reconstruction. So I think that first of all, I think that we determine what the Constitution says, not the Supreme Court. We, the people. And that, I mean, what does that mean? That doesn't mean there's no judicial review, but we should be able to pass civil rights legislation through the Congress that is rationally reviewed. If it furthers rights, not is a drag on rights that the court has identified, not prevents privacy rights or something that obviously requires strict scrutiny, but if we expand rights through our representatives, that should be a way of interpreting the Constitution, which goes to Barry's point earlier about interpreting, and I think Mark's as well comment earlier. And just as the last thing, I agree with you. I mean, I do think that that provision with neither slavery nor voluntary servitude, except for persons who have been duly convicted, was clearly a drag, was clearly used by the black codes, and was a means of perpetuating slavery after it had been done. But let me just, I apologize, one very last comment. The notion of slavery at the time of the ratification of the 13th Amendment meant something very different for them than it means for us. For them, they were referring to what the revolutionaries were saying, that they were slaves, that they couldn't vote, that they couldn't participate in government. They thought that it meant some sort of an equaling out, I think, as citizens.
So I want to respond to a number of the comments. I'm going to say two things. One is narrower and in response to Christina, but also to Richard, and that's about the grand narratives. And this is building on what Mike was saying, that there's a moment in 1941 and 1942, there are all these African-American teenagers who respond to advertisements to go work in the sugarcane fields in Florida during the war to help the war effort, and they get there and they're enslaved. And they, when they get off the train, they're told they're going to have free transportation, all this stuff. They get off the train and they go in, and the camp supervisors stand at the gate of the camp and say, if you turn around right now in the middle of the Florida swamps and go back home, you owe us nothing. But if you walk through this door and take this materials, these instruments that I'm about to give you, then you owe us and you can't leave until you've paid us back. And he was creating a contract, and he was placing them in debt and saying, you're fine unless you walk through. What are they going to do? They're hitchhiking, they can't get home. They walk through the door, and the employer clearly thinks it's fine because it's created this contract with debt. And in fact, initially, when the Department of Justice starts investigating this case, all of the investigation is about how much are the debts and how did they get the debts and establishing this. And the grand narrative is in the process of changing from this contract-based understanding of the 13th Amendment to this right to be free from bondage understanding of the 13th Amendment. And as a result, Attorney General Biddle sends around a circular and says, we're no longer prosecuting on the basis of the Peonage Act, which requires debt. We are now prosecuting on the basis of the 13th Amendment with sections, what become sections 241 and 242 of the U.S. Code, which is conspiracy to violate civil rights or state action under color of law violating civil rights, and the 13th Amendment directly. And immediately the investigations switch away from those contracts and those debts to questions of, were you prohibited from leaving by violence, by threats? How was it done? Were you threatened with jail? And it's a moment when you can actually see the grand narrative affecting the legal strategies and the laws under which prosecution is happening. And so I put that out there. I don't think it's a progressive history. I don't think we've come to be more enlightened, although I think there are greater and greater indicia of what we see of involuntariness. But it's clear that the guest workers are exactly like these sugar workers from 1941. In a larger sense, I want to say one other thing about the grand narrative, and that's that I agree that the grand narrative is the driving force, but the relationship between legal doctrine, lawyers, and the legal imagination, the grand narrative, is a really complicated one, right? So when I read, Riva, when I read Parents Involved and the two different sides calling on Brown, they're both right. The conservatives are not wrong when they quote the NAACP's brief and quote colorblindness from the NAACP's brief. And I think one of the things that happens is some pasts become invisible and some grand narratives become inaccessible, because one of the things that I think lawyers do, which is what they do really well, is build on successes. But if you build on a success and it becomes entrenched to look like a particular narrative, in the case of Brown, I think eventually after a lot of contestation, now in Parents Involved, it looks like a formal equality that is negative against the state. You lose all these other paths that might actually provide fodder for a grand narrative. So I would put out there that one of the ways that we can understand what the history is doing is to recover these invisible paths and open up our imaginations about what the grand narrative can do.
Eric?
Yeah, well, I am actually glad to hear that we live under the British system and not the American system, because if that were the case, if that's the case, then we would have a House of Lords which is much more concerned with defending individual freedom than our Supreme Court is now. An irony our founding fathers would have found it difficult to understand, since they were so desirous of getting rid of titled nobility. I think the point about the exception clause is a very, very good one, and it has implications beyond the particular question of servitude for crime. This is a point about the Reconstruction amendments and the Reconstruction Congress, which is so obvious that we tend to forget it. They expected these amendments and laws to actually be enforced. They didn't pass them expecting a century of abrogation, which is what we actually got. And they, therefore, when they passed the 13th Amendment, they thought states would actually abide by it. When they discovered they were not abiding by it because they passed the black codes, which put all these crimes into effect for black people in order to avoid the 13th Amendment and stick them back into involuntary servitude, vagrancy laws, and all this kind of thing, they said, well, wait a minute, that's not what we had in mind at all. So they passed the Civil Rights Act, Under the 13th Amendment, not the 14th, there was no 14th Amendment at that point. The Civil Rights Act of 1866 was an attempt to enforce the 13th Amendment, and that abrogated the black codes. And so people could no longer be just, you couldn't just set up a whole new bunch of crimes for black people in order to put them back into involuntary servitude. And then they passed, as we know, the 14th Amendment, the Reconstruction Acts, and when they saw the Reconstruction Acts were being violated or violently opposed, they therefore passed the 15th Amendment. In other words, my point is that this was a historical process. You cannot freeze it at one moment and say, what is the intent of the Reconstruction, the architects of Reconstruction? The intent was open-ended, which is why the language of the 14th Amendment and the 13th Amendment are so open-ended and vague. Somebody said to Bingham in the debates, well, why don't we just list all these rights that we want to give people under the 14th Amendment, like they did in the Civil Rights Act? And Bingham said, no, if we list rights, we may miss some. We want to put a principle in here that future Congresses can implement. If we miss a right, we'll never be able to get it into the Constitution in the future. They anticipated Congresses and the courts which would continue to implement and expand the principles of the Reconstruction Amendments. They didn't anticipate this long, long history of abrogation. And so the issues that we are dealing with today in the courts, unfortunately, are trying to deal with the long-term consequences of the violation of what the Reconstruction Amendments were trying to do. And that's a different kind of constitutional paradigm than if we can imagine a society in which actually those measures were actually enforced for the century after they were passed. So the exception clause is just one piece of a much larger constitutional history of abrogation of the 13th, 14th, and 15th Amendments, and we're still living with the consequences of that.
Well, just briefly to suggest I'm in heated agreement with Reva. If the agreement is that history does not privilege our vision or the Bush vision, though all lawyers must use the language of privilege as a matter of legal rhetoric, that history permits what we want to do. And once we recognize history permits, we recognize history permits a number of other things, and it's politics that decides which constitutional vision that history permits becomes dominant. That means, one, taking our emphasis off the Supreme Court onto broader political movements and what they need to succeed. And also, as we phrase our vision, understanding our vision has to have political valiance, which means it probably can't be based on a footnote to a Supreme Court concurrence, but rather on a broader vision that most Americans can identify with. And with that, we can have lunch.
Thank you.